So this is day 3 of the Billy Chemirmir trial. I am joined today by David Finn. He is a former state and federal prosecutor. Hold on a second, David. Is your computer fully silenced?
I think so.
Yeah, it's.
Wait, let me try something. Is that better?
We're still doing it. You know what? Let's just shut the computers. Let's just shut them. Just shut the computer. Yeah, just shut the top.
Okay.
All right. That should fix it. Did that do it? God, why are we? Okay, sorry, I've still got an echoing in my ear. Sorry about that. So I'm Tanya Iser. I'm an investigative reporter here at Channel 8. I am joined by David Finn. He is a former state and federal prosecutor, also a former trial judge. So thanks a lot to David for joining us today. I want to give a brief recap of the last couple of days of what we've seen during this trial. Prosecutors have very much presented what I would call a chronological, step-by-step case of basically building the building blocks. The first day was kind of very much like a foundation. We heard the 911 call. We heard from the paramedics and police officers that first responded to Mary Bartell's house. Mary Bartell was the attack that kicked off this investigation on March 19th of 2018. She described to police that she saw a man wearing green gloves. She could not describe him, but a neighbor's son had the wherewithal to record a license plate, an all-important license plate, and that license plate leads investigators to Billy Chemirmir, and then that sets in motion a string of events that leads them to find the body of Lou Harris. And Lou Harris, that's the case that's being tried right now. Lou Harris was found murdered in her home. And the interesting thing about that is when they captured Billy Chemirmir, actually how they came to come to Lou Harris's home was that when they found him, he was dumping a red jewelry box in the dumpster, and inside that jewelry box contained some items, identifying items that belonged to Lou Harris. And yesterday we heard from Lou Harris's son-in-law. We learned that she was this wonderful lady who had met her husband in Vietnam, and during the fall of Saigon, she fled on a helicopter and ended up coming to this country and made a life. And so he also, during his testimony, vouched that a number of the items of jewelry that was discovered with Billy Chemirmir belonged to Lou Harris. And also, she had a thing where she liked to give $2 bills to people that were special to her. And so Billy Chemirmir was caught with a whole bunch of $2 bills. The other thing was that we heard testimony from the medical examiner who testified that he found petechial hemorrhages. That's on her neck, shoulders, and back, I believe. But he also said that but for all the evidence that had been gathered, this would have likely been ruled an undetermined case. Many of the prior cases that actually were initially ruled natural. And so, through this string of events, we are here today on day 3 of the Billy Chemirmir case. So Judge, let's kind of take a listen, or I want to talk to you about what you think so far about where things are headed.
Well, the defense doesn't have a lot to work with, and this is, kind of the equivalent of what's called a slow plea, and it's a circumstantial case, but it's a strong circumstantial case, and this guy just flew into the radar screen for years, and we've got 20 victims. Elderly females, so he's not the most sympathetic guy on the planet.
Yeah, and of course, that's the interesting thing about this is, the type of victim he was choosing, elderly, lives alone. And a lot of these women they weren't living in like assisted living facilities, they were living in more like senior living facilities. So these were people that were really with it. And when you think about it, for me, one of the key things is this neighbor's son who records this license plate. You just know that this really could have continued a lot longer.
Yeah, it could have, and he got away with it for years and years. I think that what the public here in the Dallas-Fort Worth area is asking themselves is, why isn't the DA's office and Judge John Creuzot going for the death penalty? I mean, if killing 20 people, elderly women, suffocating them in their beds, if that's not worthy of the death penalty, what is? And I've got to think it's just he's just got an objection to it because initially he said he was going to seek death. And, Collin County and Bill Werski and Greg Willis may end up going there. But, I've talked to people in the supermarkets and they're just like, oh my gosh, really? He allegedly killed 20 people? So I don't want to prejudge it. I mean, everybody's entitled to their day in trial, as we've seen up in Wisconsin with that murder trial that's, jury's out on that. But it sounds like it's a very compelling case that the prosecution has.
It is, and you're right. He did originally announce that they were going to seek the death penalty, and I know that a lot of the families are really angry that he did not continue down that path. We've actually had one family member, I don't know if he's on the stream yet, who's made that very clear. And the other thing the families are angry about is because of COVID restrictions, they're not allowed in the courtroom. And you know how courts are currently constructed. I don't know if they should have waited to do the trial till we could, get outside of these restrictions. I don't know. What do you think?
Well, he's been in custody a long time. The family wants closure. I was Dallas's family violence judge for 4 years. Rocky, the judge, Jones, was actually a prosecutor in our court. And, the family wants to be heard. And so I don't blame Judge Jones for pushing this through, but I do feel for the family because it's just almost impossible to be heard in this, environment we're in.
It is, and like even the way that the courtroom is laid out is very different. They've got the audience, where the audience would normally sit is where the jury is, and where the jury box is actually empty except for a pool camera. Oh, we're starting to hear some chatter in that courtroom.
Well, Tanya, your viewers will relate to this. I've got 3 daughters and a son, and if some son of a gun murdered one of my kids, I'd want him dead. And I don't care how much it would cost or how long it would take. I mean, you kill, and I got mixed feelings about the death penalty. I do.
No, I get it. I mean,
believe that is too remote to go into.
It would cost millions of dollars.
The defense not to go into that. We've basically made an oral motion.
Let's listen a little bit to I'm trying to figure out what's going on.
If I may respond to the purpose of the record, Judge?
Yes.
Judge, in accordance with Rule 609 D of the Rules, Texas Rules of Evidence, we concur that the conviction is outside the 10-year window. However, that rule allows us to attempt to get it in if, and I quote, evidence of the conviction is admissible only if its probative value, supported by specific facts and circumstances, substantially outweighs its prejudicial effects. We do believe that, in accordance with that, we would be able to get into this conviction regarding this witness. However, due to trial strategy, we determined and decided not to go into that, and so we will not seek to do that. And we've counseled and conferred with our client, Mr. Chemirmir. And just for purposes of this, Judge, can I ask you just a couple questions in regards to that?
Yes, go ahead.
And I believe he's been sworn.
He has not.
Okay.
Mr. Chemirmir, would you please raise your right hand for me? Do you so solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
All right, you can be seated. Go ahead, Mr. Warren.
And Bill, you just heard me put a couple things in the record in regards to that witness that they have coming up. Is that right? Yes, sir. And you, myself, Mr. Watson, and Ms. Silver, we just had a discussion regarding that. Is that right? Yes, sir. You understand that we reached an agreement as a team to not go into that, and we believe that's for strategic purposes and that benefits you and our theory of this case. Is that right? Yes, sir. Okay. Any questions on that? No. Okay. That's all I just think.
All right. Is there anything further we can put on record?
Yes, Judge. Today there will be a number, or a few witnesses that are familiar with Mr. Chemirmir and have had dealings with Mr. Chemirmir. And I will be asking them to see if they can identify him today. So far in trial, Mr. Chemirmir has been wearing a mask that covers the bottom portion of his face. He also is wearing glasses, which I don't know if he's common to have done that in the past. I brought down a clear face shield so that he can wear that today, so that I don't have to ask him to remove his face coverings throughout the trial, which I think would then be, I don't know, maybe unfair to me to say, you know, ask him, if I'm asking someone to identify someone, say, can you take your mask down? And so I think that, in all fairness, I think that they should be able to view him as he was at the time.
But Judge, we would object to that for a few reasons. One would obviously be due to the COVID-19 virus. Mr. Chemirmir, since he's been in custody, every time I've been around, he's always worn a mask that covers his nose and his mouth. Secondly, throughout the proceedings of this trial, Mr. Fitzmartin has had individuals identify Mr. Chemirmir, and they've been able to do so. They've looked and then they identified him on articles of clothing. He's been identified on the record. So I don't think that's an issue, and so we would object to that.
And for the record, Mr. Chemirmir does not have his mask over his nose or half of his mouth right at this moment. So I think that we can ask him to wear a face shield that protects us. That's what everybody else is wearing in this proceeding, is a face shield. And I think it's safe enough.
Well,
Yes, Mr.
Your
Watson.
Honor, I'm Mark Watson, and I'm wearing a mask. Billy's been wearing a mask 95% of the time. Miss Tanya's been wearing a mask most of the time. And I think Kobe's been off and on wearing a mask.
Well, he's not right now, so I just think that maybe I think it's unfairness that my witnesses will be able to look at him as he appeared at the time.
So, all right.
Judge,
Go ahead.
just real quick, Judge. And Mr. Chemirmir needs his glasses to see, and it's difficult for him to wear the glasses as well as the face mask.
I'm okay with the glasses as long as the shield is on there so that we can have an opportunity to look.
Okay, so, well, of course, I'm not gonna make a defendant take off his glasses, because I don't know if he needs those to see or not. And I don't know if I necessarily have what I may be willing to do is state, you said you have several witnesses that you would ask to identify the defendant, right, in open court?
Yes.
And what we may be able to do, because I will say this is new. Of course, we never had this during the pandemic, where we can order a person wear a particular covering for their face. Matter of fact, we can run. I may be willing to allow for the mask to be taken down, not necessarily the state asking.
I would suggest if the witness requests, then we obviously, then that would be fine, but I don't want the state to say, hey, we'll ask him to. I would just say, once he asks them to identify Mr. Chemirmir, if they look over and they say, well, I'm not sure, couldn't he remove his mask? And I don't have an issue with that.
Or like, could everyone at the defense table pull their mask down?
Yeah,
That way you're not.
but-
Well, I
feeling
think
that.
what Mr. Warren is saying.
If that
is
witness
the same.
desires that, I don't want you guys telling your witness, hey, tell him to remove his mask or do these things. Just if when you ask them to identify Mr. Chemirmir, if they look over and they say, well, I'm not sure it looks if he can remove his mask, I don't.
Well, these are not, Judge, these are not professional witnesses that know how things go in here, and so they don't know that they can go, if I can't go and tell them, you can ask them to take down a mask, and now they're just supposed to come up and figure out that they can tell someone to take down a mask.
I think, and I could be wrong, but I believe what we're trying to prevent is the state basically saying, Mr. Defendant, will you take your mask down so that they can identify you?
I mean, I'll be happy to do that if that's what you, if that's what
No,
you
I'm
all
saying
want me
that's
to
what
do.
they're trying to
I'm
avoid.
trying to prevent doing that,
Yeah.
you know, and trying to make it so that he is in, everybody on this side are in these face shields. Mr. Warren has been wearing the face shield. I see other participants in this proceedings wearing the face shield. I don't understand why one person can't wear the face shield if we deem it.
Are your witnesses, they're civilian witnesses, I take it, are they
Well,
back to back?
Detective Tabor, he interviewed him. Detective Martinez interviewed him. Tom Onding knows him. Detective Chapman is aware of him. Adele Soleil met him for one day in making the purchase. So I mean,
So
there's,
it's for today,
and then tomorrow there's another one tomorrow.
So I agree, I do not want it to be, of course, none of us want to do this public display of, hey, Mr. Defendant, pull your mask down and then ask them to identify. So we do have the option of, just to be very clear, if he has it on, then there's no need to ask for it. Now, what I understand Mr. Warren to say is that if the witnesses are to ask, you know, I'm not sure, can the person pull their mask down, you have no problem if it comes from the witness stand.
Correct.
You just don't want it to come from the defense stand.
That's correct.
So your first, yes, Mr. Watson?
And Judge, for the record, yesterday or the last two days of testimony, not one state witness that's been asked to identify Mr. Chemirmir has been unable to identify Mr.
No,
Chemirmir.
actually, that is incorrect. Richard Flink had an encounter with him and looked around and said, I don't know if I could identify him. And I looked over and I realized, well, shoot, he's got a mask on and some glasses. Maybe if he didn't have that mask on and some glasses, he might have been able to do it. But I was stuck at that point in time because I didn't want to ask for the defendant to remove his face coverings and then indicate to the witness who I wanted him to focus in on. And so I thought, well, the best way to deal with that with other witnesses who I know or have had encounters with him was to provide him with the same safety measures that the rest of us are using. And that way he would not be in a position that I have to now draw attention to him.
And Judge, just not to belabor the point, I know the court's ready to move forward, but just making the distinction with Mr. Flink. Mr. Flink saw Mr. Chemirmir one time 3 years ago. And the difference is with the witnesses, he just looked it off with Detective Tabor, Detective Sayers, these detectives from Plano. They spent a considerable amount of time with them. Like I said, we all around this courthouse, we wear regular masks, we don't wear shields, and we're able to determine, we're able to identify people each and every day, Judge, by our eyes and the shape of our head, our body types, and things of that nature. So I don't think it's that big of an issue. I think it's prejudicial to force him to do that, and we're going to object to it. Like I said, if the witness, we've all done this for 20 years, Judge. The witness can't say they'll ask him to do something. Hey, could you move forward? They'll do the counting. There's a lot of ways for the witness to identify him. If they can, so be it. If they cannot, so be it. But we're going to object on that, and we'll just ask for a ruling, Judge, and we'll go from there.
And Judge, just to respond to that, I do have a witness that's coming up that's a key witness that had an encounter with him for about 15 minutes one day 3 years ago. And so I think that he should be able to have a view of him as he was back then. And to say that we know everybody in here, I've had people asking me, who've been watching this online, why are you sitting behind the defendant when they're looking at Mark Watson? And so because he's covered up with a face mask. And so I've been misidentified as being sitting close to the defendant. And why am I allowed to do that? And so this is not the normal circumstances, and it's not like I know that that's Mr. Warren out there because I know Mr. Warren for about 20 years. These are chance encounters 3 years ago, and it's just putting us into a tight bind with trying to get this case prosecuted when he is covered up. He's wearing a mask. That's what robbers do so that they're not identified later on. And if he's wearing this type of, when he has another way of doing it that's clear.
Judge, and again, this is Mark Watson, and Your Honor, this gets into suggestive IDs. He's the only black guy sitting at the defense table. Well, we got Kobe over here. That was a mistake.
Yeah.
Hey, we got Kobe over here, Mr. Warren, who, to me, obviously, you can tell he's in a position of authority running the show. Then you've got Tanya in the middle. She's obviously not the defendant. Then you've got me, a white guy with a bald head that looks like the prosecutor. So it's not rocket science for the witness to say, oh, that's him right there. That's Mr. Chemirmir. So that's entirely suggestive. If they can pick him out, fine. If they can't pick him out, fine. But 9% of these witnesses, the actual ID of these ancillary witnesses is not crucial to the state's case.
All right, thank you. We're going to be off the record. Let me make sure that I am.
Yeah. So you can see that we've just a huge argument over masks. What do you make of this?
This is what gives lawyers a bad name. I mean, I understand the gravity of the circumstances, but Judge Jones is just shaking her head and rolling her eyes like, he's been wearing a mask for the last 2 days, and that was never an issue. So I think if the prosecutor, Mr. Fitzmartin, fellow Jesuit grad, had it to do over again, he would not have raised this. He doesn't need it to prove his case, and they're fighting over ancillary BS. And and I think you could see the exasperation on the judge's face. She's like, really? We're having this conversation now?
Yeah, exactly.
Yeah. I mean, I know Watson too, and I don't think identity is the issue, right? I mean, maybe I missed something, and if identity is not the issue, just let the guy wear a daggum mask. He's been wearing it for 2 days, right?
What's interesting to me is that this is the most the defense has actually argued during the whole trial.
Tanya, they don't have anything else. So they're getting, they had their Starbucks this morning and, raced to the courthouse and, they're doing what they can, but, if you got a losing hand, you got a losing hand.
Well, yeah, and I don't know how you explain all the circumstantial evidence. How as a defense attorney, let me ask you this: if you were defending Billy Chemirmir, what would you do?
Very little. Credibility is everything with the jury, Tanya. I knew that as a state, federal prosecutor, and as a defense attorney for 20 years. They got to trust you. And if the jury doesn't trust you and they think you're trying to pull a fast one with some slick lawyer moves, they're going to hold it against you and you're going to get hammered. Well, you won't, but your client will. So, you got to pick your battles. You want to win the battle or, win the war, but the evidence in this case seems to be overwhelming. So, imagine you're a defense attorney. What would you do?
Well, I want to introduce you again because some of our folks on YouTube are asking who you are. And this is David Finn. David is a former federal and state prosecutor. He's also a former trial judge and longtime defense attorney. David and I have known each other for a long time. We go way back. So I thought he would have fun doing this. So
Tanya, that's attorney-client privilege, by the way, how long we've known each other.
We're going to start to age each other.
I know. No.
So if you're, so yesterday, basically we ended up, with the medical examiner's evidence where they said, but for the evidence, that little thing called evidence, this would have been ruled undetermined, that Lou Harris's death would be ruled undetermined. Does that give the defense any kind of opening at all?
No. I mean, Tanya, this case in my mind was over when the witness